Can? Okay. I'm going to wait for Alice to give me the thumbs up, and then we'll start again. Okay.
After work session. After work session. After work session.
Okay. Okay. Yeah. And yes, I think Paul said they could hear us now on Zoom. Okay, Albert, you're up.
Okay, all of you probably know me anyway. I'm Albert Harmer with the Springville Irrigation Company, and Hobble Creek Canyon's been a real problem since the 1980s, okay? And I think the county has been aware of that since the 80s on it too. And the county has some big responsibilities here because they're getting building permits out with not a sufficient water right up the canyon because they've been under litigation for an extremely long time, okay? And what's happened, the state's seen there was a problem up there, and so they've set a special master forward to solve the problem. They just didn't do it in Hobble Creek Canyon. They did it down the Wasatch Front, and they finally hit Hobble Creek Canyon now and trying to solve the problems. And they found out Hobble Creek Canyon is one of the worst to deal with on it. We've been in litigation a long time, and I can't talk about the litigation part of it because it involves the Hidden Quick Water Company, what's we're talking about too right now on it.
Can I interrupt you just for a second to announce
Mm-hmm.
that Commissioner Gardner's back with us?
Oh,
Go
okay.
ahead.
All right. So anyway, it's been under litigation a long time, and some of the litigation we're talking about right now is with the Hidden Creek Water Company, and I can't tell you any more than that. They were just under litigation on it. But there's water rights up the canyon that are the 1851 rights, which are all owned by the Springville Irrigation Company, okay? And there's users up there that have these rights in the company to use water. And my big concern is the whole thing. I have a lot of users up the canyon, approximately 400 of them, that I have to provide water to, and so I have to litigate with all these people that have a so-called water right, and so I'm trying to protect those users that are up the canyon, and not only just the canyon, it's the downstream users too. Mapleton Irrigation Company, which provides all the water for Mapleton City, and then also Springville Irrigation Company that provides a lot of the water for Springville Irrigation, for Springville City, and also for on down the clear on into Salt Lake County, okay? Because it goes to the lake, and then these people have rights in the lake and so on and so forth on it. So there's a big litigation area that we're covering here on it. And I'm open to work with a lot of people on it. I've been trying to do a lot of working with everybody on it, and I'm open for it. And we need to sit down and do a lot of talking about it, but right now I can't talk too much about it till some of the litigations are being solved on it, on the thing. And I'm sure there's going to be a lot of people up the canyon going to be hurt from it when we get through with the litigation on it and the thing. And that's all I've got to say right now. Okay, and if you want any questions, you guys got any questions you want to talk to me about?
Is there any way that we could sit down and work some things out even before somebody gets hurt up the canyon? Is that possible in your mind?
We can sit down anytime and talk about it on the thing and so on and so forth on it. But you got to remember, before anything can be resolved, I have a board that I have to okay with too on it before anything is signed over on it or done whatever on it. And I understand where these people are up the canyon on it, but these people should realize too that, and the county also, that these have been under litigation since the 79s and 80s, okay? And it's partially the state's problem because they took litigated water that's under protest and gave it out to certain people and switched it around and so on and so forth on it and pushed it into wells and so on and so forth on it under litigation. So the state is a big problem with all this issue too, and the state's found out they have an issue. And the state stepped up and seen that they had a problem, and that's why they put a creek master up there to monitor the creek and go on priority dates on it. And that's helped a lot so far, and there's going to be more process with that process as they go on it. So anytime you're open, I'm open to talk with anybody on it, okay?
Do you think there's a possibility, though, that if we were to sit down, that we might be able to solve these things
I think some issues could be solved up the canyon. I think there is some areas that could be solved. You take the people they're down there right now, they probably are one of the best ones up the canyon because there's shares involved in their water rights. And them water rights there they have a full year use on it, their 1851 rights, okay? So they're probably in a better standing than anybody else in there, but it's other things that go along with it that's causing the problems up there.
Sure.
Any other questions? Okay.
Thank you, Albert.
Thank you.
All right. Was there anybody online? Was there, Alice? Okay. If there's one person online, Alice, if you'll allow them to speak, if you just make sure and state your name.
Yes, it's Jenny Lambert.
Okay, Jenny, go ahead. Jenny Lambert, go ahead and speak to this issue.
Can you hear me?
We can hear you.
Okay. I'm sorry. I wasn't able to be here this time, so thank you for zooming me in with you. I just want to remind you that I am the one who lives in Upper Whittemore. I have a permit that is being held up. I'm doing a remodel. They did give us the 4-way, but we're still not going to be able to do a final inspection on that. As far as, again, like this other gentleman said, we've been asked to sign this waiver releasing our water rights that we don't actually own. Upper Whittemore owns them. We do not own them as individuals. So it doesn't really apply to us. As far as the need to be notified, I think that's wonderful. That's not a problem at all. But this waiver that they've asked us to sign, it's a disclaimer, waiver, and release. This is not just a notification. This is so much more than that. This document, like I said, I've had 2 attorneys look over it. It has a lot of teeth in it that shouldn't be there. A simple notification releasing the county, I don't think anybody, you're asking us to come together. I don't think anybody's disputing that. Nobody's trying to go after the county. But when you read this, you feel like the county's coming after you. That's the way it makes you feel. And it says in there that any use, occupancy, development, or improvement of said property or continued use of said property shall be done by the declarant at its own risk of such pending legal action or loss of certificate of occupancy. So if I lose water, which could happen, I'm acknowledging that, they could take my CO away. And like I said, you have to make some sort of an exception for existing homes, for remodels, and in our case at Upper Whittemore, these are not homes that we live in year round. This is recreational use. We're only told in our CCNRs that we have 180 days a year up there. So it wouldn't apply to us, and you have to make an exception for that. If we lose our water, it's recreational. We haul up porta potties, we haul up some water for the day, we go up and we still use our property, and then we go home. We're not living there like so many other people are. And so that's what I'm asking, is that you will look over this waiver that they keep putting it across like this is just a very simple waiver. It's not a big deal. It is a big deal. It's not just a simple waiver, and it needs to be rewritten for that reason, so that it's not throwing. There's so many different scenarios, and you can't throw everybody into one category. I can't sign rights away that I don't own. Same thing. Other Whitmore's a private water company. I don't own it. And again, I have a cabin that I'm the only person that they're not letting me finish and nothing is changing up there for that. And so there needs to be, and again, it's a cabin that's recreational. I'm not going to live there. I can't,
Right.
even by the CCNR do it.
So
So
I
that's
wonder,
all I'm asking is,
I wonder if you could just hang with us. I think that we may get to a lot of the points that you're
come
talking
together.
about.
Okay. I appreciate that so much.
And maybe if I
one thing
could just,
throw in this. Okay, I think that does it. If I
Okay.
could just throw in suggestion of water meters too, if that's necessary. It's something that I don't think someone, in our situation would object to either. So
Okay.
thank you so much for your time.
you bet. I think that maybe if I don't know, Bryce, if you want to address the first part of her concern. The second part, I just want to reiterate that when we send it to the Planning Commission and it comes back to us, we're taking recommendations, and that's what you see, that's what you saw, and that's what we're working on is recommendations. And again, I know just from conversations in the past meetings that we were at or not at, there was one that I was not at, but I heard what was going on there. I think that the commission is headed in a direction where that there's A, B, and C, and the C one, which a lot of the concerns were being brought up, but I think that we're going to address that.
Bryce Armstrong, staff. As to Ms. Lambert's first question about her pending permit that was released following our most recent meeting, there was a restriction that allowed her to go up to 4-way until either you guys acted on it or the pending ordinance expired, and that was written into her approval.
It already expired.
And that expired on Monday.
Yes.
So her approval contemplates that she has the full ability to go forward. And so Ms. Lambert, if you're still listening, you go ahead and contact us, or you can look at that approval that was included in your permit that was issued.
Okay. All right. Thank you. We have on our agenda this item following with this right now that we're in with the work session is not actionable. So thank you for the discussion. We will now look to build our agenda.
May we take a 5-minute
Oh,
recess?
I'm sorry, you said
There's a
you
couple
wanted-
things I need to address and be right back.
Okay. All right. We will take, we've got 1 hour left, so we'll take a 5-minute break. All I can think of is emergency help. Okay. It's totally fine. Okay. So Alice, do you need, yeah, go ahead and push. Did you want this off?
No, I'm ready to start, so I'll have him.
Okay, you don't want it lit though, this button.
I think I already unmuted it.
Okay, okay.
So if you can make sure you're unmuted.
Yep. Okay, and you pushed the button on that? Okay. All right, welcome back. We do have the rest of our agenda, and we're going to do it easily within an hour.
Okay.
And so our consent agenda, as you'll notice on our consent agenda, there's nothing underneath it. We're going to hopefully fill that with lots of those on regular agenda that we've agreed to, either that we've looked at separately, but we've agreed to because we don't have any questions to it. We'll place them on the consent agenda. The items that we hold will stay on regular agenda. So let's start with items number 1 through 10. I know that number 9, it's been asked that we continue that one for 1 week. So if it's okay to leave that on to continue for 1 week. And of course, number 5, we will hold.
Do we need to get, based on the work session, do we need to continue number, the 6.04 item? Is that the one you mentioned?
Yeah,
Five?
that's number
That's
5. Yeah,
I had 2 different agendas. Want to make sure I'm following correctly.
I know. Okay.
So
Yeah.
5,
So
we're
on
gonna
ours the one that we officially published out there,
Okay.
it's number 5. That's
Okay.
the 6.04
I just,
one.
I've got the right one then
Okay.
after all. Okay.
Any others from 1 through 10? Oh,
All right.
yes. Oh, yes. Okay.
Yeah, number 10, it was a little confusing. Negotiation or award. And so I'm not sure.
Okay, we'll
how that
hold
one
number
should work
10.
out.
Thank you.
Thank you, Robert.
Number 11 through,
Go to the end.
let's go 11 all the way to the end. The only thing I wanted to say on number, leave it on consent, but thank you to whoever Anonymous is. Hopefully you're listening or you know, but anyway, thank you, Anonymous.
Yes, absolutely.
It's not done anonymously. We're just thanking you publicly. How's that? Any others?
Just only to note that number 14, that's coming from state grants. That's not a county or ARPA funded.
Yeah, it's ARPA fund. Yes. Okay, thank you.
And then items 22 and 23 to hold.
22 and 23 to hold. Okay, so Alice, would you kind of run down through our agenda so we'll know which ones are going to be held on regular agenda and which ones will therefore
Okay.
then go to consent?
And I apologize, when you were doing the first 11, I was having issues with
Okay,
our machines again, so
Number
I did
5
not
we're
hear.
holding. Number 9 we're continuing for 1 week.
I'm sorry, can you say that again?
5 is holding. 9 is continuing for 1 week, and 10 is holding for action. And then 22 and 23 is holding.
Okay, I apologize here. Okay.
you okay?
Got it. Thank you. All right, so I will repeat it all again.
Okay, go ahead.
Sorry. Okay, I have that we're holding number 5 and going to continue number 9 for 1 week. But Commissioner Gardner, I think that the email that I received is they're requesting 2 weeks.
Okay.
Oh,
do
I'm
2
fine
weeks.
with that. If
We're
we
fine
want
with
to
2
go.
Okay.
weeks.
Yeah, 2
Yeah.
weeks, hold for 2 weeks.
And then we're holding number 10 and 22 and 23.
Very good.
Thank you for that.
Okay, number 5 is to adopt an ordinance to amend section 6.04 related to the approval of water and sewage disposal. We talked about this in our work session, so this is not one that I would anticipate there would be a lot of discussion with. And the paragraphs are fairly small, and I think that in the reading of it, I don't know, Rob, if you would just like to come up and read those 2 paragraphs. I just want to make sure it's absolutely clear, and then we'll have discussion if we want to. I'm inclined to strike the C paragraph, and so unless another would like to have that one read, maybe we just read A and B, and
Yes.
then we'll hopefully be on the same page.
Sure, Rob Moore, County Attorney's Office. So 6.04 as proposed from A and B, which came from the Planning Commission, And you want me just to read subsections A and B only?
Yes.
Okay. So A says the owner of the lot or parcel that has signed and recorded in the office of the Utah County Recorder a restrictive covenant, acknowledgement, and disclaimer in a form acceptable to the Utah County Attorney's Office, which acknowledges and gives notice of the potential of a determination by the Utah Division of Water Rights or a court of competent jurisdiction, which may reduce the quantity, pressure, flow, or delivery of the sources of water, and releases Utah County for any damage, liability, obligation, or loss that might subsequently occur or arise as a result of any reduction of water. That's A. B says, if the source of water is subsequently reduced or eliminated below the required amount for the subject structure or use through a determination by the Utah Division of Water Rights, by a court of competent jurisdiction, or for any other reason, then a replacement source of water shall be provided that meets all applicable requirements for quantity, pressure, flow, and delivery, subject to the following, and there are 5 exceptions. If the replacement source of water serves as a use or a structure located on a parcel, the amount of water required shall meet the applicable requirements of the most recent approval of a land use application for the structure or use. 2, if the replacement source of water serves a lot or lots within a recorded plat, the amount of water required shall meet the original requirements of approval for the plat. Number 3, the replacement source of water shall meet the requirements of this section. Number 4, if a replacement source of water is required subject to the provisions of this section for a lot or lots within a recorded plat, a recorded document in a form accepted by the Utah County Attorney's Office to permanently provide the required quantity of replacement water to the subject lot shall be required. And just note that we already require that in our ordinance now for other subdivisions, et cetera. Number 5, if a replacement source of water is required subject to the provisions of this section for a lot or lots within the recorded plat, an amendment to the existing recorded plat shall not be required. That's A and B.
And as I understood it from the lawyer that was representing the cottages, he didn't see any problem with A or B in this. Would you go over the form on this to, I'm seeing no, their heads being shaken, no on this, but this is mainly just a notification process or then requirements that we've had in the past?
So A would require an acknowledgement and waiver and as determined by the county attorney's office. That's A. B would require replacement source of water, and there are some exceptions that were identified, 5 of those. C is what really was the big issue, and it was tied specifically to Hopple Creek, and that required an attorney opinion or an engineer opinion that the water was sufficient, and that's what cost.
That was the teeth of it.
Correct, and that was C, and that's the one that in our discussions from previous meetings, both here and privately, I think that's the one that you've had some concern about with as well.
And this also applies, as I understand it, to new applications. In the form, you have new applications in which they're going through this process.
Correct. So, for example, Ms. Lambert, who was here earlier, this would not apply to her at all because the time frame is run. So if we have a new application after this has been approved and gone through the process of approval and provided notice, the 15 days and et cetera for approvals of ordinances, then it would be effective and new applications would come in and would be subject to this ordinance. It would not be subject to existing homes out there.
They're up there already.
Yeah.
We're not going to be going up there asking them to sign off on
Correct.
on this.
This would
I
just
don't
be
think
new
we can.
homes.
Right.
I think they have to come in and apply for something. And that's when it kicks in. Right.
Okay.
Questions for me? Other questions?
No.
I mean, I'll mention this too. Some of those points that were brought up about further discussion, those are great, and we should have those further discussions. I think you could move forward on 6.04 on A and B today if you decided to do that, and then that would just kick in those requirements. But those further discussions clearly can happen, or you can continue it if you want to, or whatever options you want. You certainly have a lot of options here.
To reiterate, A and B does not affect existing homes.
Existing homes, they came in for a remodel.
then
It-
they
it
would
could.
have to acknowledge that there's a chance the
Correct.
state could restrict their water.
yes.
But as is anyone who currently has
Right
a-
now, we're not going to go knock on doors and ask them to sign this document. No.
Yeah. So if you're going to remodel and change out a room, but leave plumbing essentially the same, no additional water, there would be no need to get an engineer to verify.
The engineer stuff would be knocked,
that's
if you
gone.
not that off
Be gone
on a
anyway.
C,
We're not
that's
even
not going to be in
gonna
any home, whether it's
Right.
new or for this particular issue.
Yeah.
Yeah. I mean, you may have to have engineer requirements for building permits.
Yes.
But not for the water requirement. Yeah. Other questions, concerns for me?
Okay.
Right.
It looks like there's, how about if we just take two? We'll take two of you? All right? Because we are,
We may have our attorney here to represent us, because we don't like what we're hearing at all.
go ahead and come up here.
My name is Russell Pearson. I'm nobody's attorney, except a fool. But the preponderance of people within the cottages have issues with A and B. Now, I'm not saying rewrite them. I'm not here to give you new ideas or how to solve. That's not my gig. I'm just speaking for some friends of mine and people that live around me. The one question that I would have, and
It's hard though, because we don't know what that is.
Okay, the question that I do have, and my thought is on subsection A, that we're to put a restrictive covenant, acknowledging and disclaimer, really nice words, but still the issue is there. If Utah County, which we've heard in these meetings, now that we've been to these meetings, Utah County does not believe that they're culpable in this providing agreement that is being, or that was given to homeowners or property owners within the cottages. Even though their name's all over it, they say, there's nowhere in that document that says we have this responsibility. Well, if you have no responsibility, why do you want us to sign a covenant saying and releasing you from any responsibility? So I'm hearing two sides on this.
What we're saying is we don't want there to be responsibility if the state restricts water. We're not the ones actually restricting water.
Okay.
Right.
And
So
I
we don't wanna be
understand.
held
I
accountable
understand
for
your
what
point
they
of view.
do.
The
Right.
state could, stick it to somebody three rungs down the ladder, and then people are coming after you because you've approved the subdivision. And I get that. Well, we as property owners don't want the value of the properties within our subdivision to go away, because in order to get your permit, you have to sign this release. So, and that's a real issue. That has a real money value. Years ago, I bought a 10-acre piece of property. Somebody came to me and they said, we can be sure you get the zoning you want, but you're gonna have to give us 1 acre of your 10 acres. We're told that's clearly illegal until we mentioned that the county was the one requiring it. So it's a bit of a funny standard, and I understand the counties need to hold out zoning or hold up permits for building to get what they want. But it seems a little underhanded and unseemly for Utah County, frankly, to be holding permits up for a purpose like this. Give me a legitimate reason you can hold up a permit. I don't have water. Okay, I get that. You can't build there. But I have water. Well, you're going to have to sign this release or we're not going to give you the permit. That's the unseemly part of it. You saw a number of people here from the cottages, and the reason we're here is to show support and to hopefully find a way through it. The second reason, and to me this is the most important thing, there have been meetings held without any of our knowledge. You've heard the old statement, if you're not at the table, you're on the menu. We feel like we're on the menu,
What meetings?
the menu that's going to be eaten.
No,
what meetings?
What meetings?
We just heard mention of meetings that have happened without people being here.
Those
So-
were discussions that were held after the public meetings to try to reflect with the public input.
Okay? Okay.
Well, or a meeting that we have with the attorney so they can help us understand.
Okay, and we appreciate that. And that's why
And
we've
it's not
hired.
even meeting with all of us. It's like me meeting with an attorney to help me understand, and Bill meeting with an attorney to help Bill understand.
And that's why we've hired an attorney, so that we can have representation in those meetings. We can't have representation
But you can't have representation when I'm meeting with my attorney. There's an attorney-client privilege there.
Perfect. And we again would like that representation. We were encouraged that Section C will be eliminated. I just want to be sure that all of it will be eliminated, that it will not be reconstituted in different verbiage and slipped back in somewhere. And that's probably our biggest concern. I appreciate your time. Any questions that I might help you with?
Thank you. Okay, hopefully did that solve, was that your same questions? Well. You have to come up here.
Oh, yeah, we're right.
My name is Randy Westbrook, and I'm
Yeah. So you've got till 3:55.
355.
Yep, and then I'm going to have to say,
That's all I need.
okay,
I guess what we'd like to do is table this A and B thing until we have proper representation here, because we were all under the impression that we were going to be fine with getting this C thing removed. That's not what's happening here, because you guys are trying to make a decision, which we'd respectfully appreciate, but there's some language in that B section that does not represent us in any way, shape, or form.
yeah, it's kind of interesting because I thought I asked the attorney that question. Are you fine with A and B? And I thought he was alluded that A and B was,
Coming as of notice.
yeah, so anyway, I mean, okay,
Yeah.
well,
So that's all. I have
we're only going to
say.
take this one here and then we're going to move on.
If we can table that and get people
I don't have a
together.
problem tabling it to make sure. Do you want to
No.
just?
Let's
you okay
go ahead and
with
get that resolved.
We can
Thank
do
you.
The
that.
lawyer that was leaving,
We
he
can do
sounded
that.
pretty happy with A and B, but I
Yeah.
said, I'm
It's
looking
confusing,
for, I
'cause-
asked it,
Yeah, it's-
keep on
it's
working with
confusing
community
to us.
development.
So that would be great.
Let's just go 1 week with it.
Thank you.
Then I will make a motion that we continue item number 5 for 1 week.
And I'll second that motion.
Okay, and we got a motion and a second to continue that item for 1 week. All in favor, say aye.
Aye.
Aye. That's continued 1 week. Number 9 is continued. Okay, this one, number 10, we have to make a determination. Oh, my goodness.
Hi, Robert Baxter, County Purchasing Manager. Actually, looking at it, I'm not so sure that it couldn't have just gone on consent because there was only one submission made, but I wasn't certain, so I thought it'd come up anyway. This was for a request for statement of qualifications for, it's a long, let's see, for engineering and construction surveillance services for the rehabilitation of Santaquin Basin. We only received one submission. That was from RB&G Engineering. Public Works went over their statement of qualifications and found that it was satisfactory. And so we're asking for your approval to move forward.
So if we make a recommendation that we've received this, and as stated, number 10, we should be fine.
Yes.
Okay.
I'll make a motion that we adopt and award the contract to RB&G, is that correct?
Yes.
Recommend for further negotiation and award, right? Yeah. Okay, and I'll second that motion.
Got a motion and a second that we received it and that we award it to our B&G Engineering for further negotiation and award. All in favor, say aye.
Aye.
Aye. That passes 3-0. Okay, number 22, to approve and adopt a resolution declaring the support for repealing and replacing the death penalty. Commissioner.
Yeah, give me 1 second. So this is a resolution to declare support for repealing and replacing the death penalty. We, as a county, do not actually have the ability to repeal and replace it, but this is a resolution to support the state legislature repealing and replacing the death penalty. And I'll read that. It says, resolution declaring support for repealing and replacing the death penalty. Whereas the proper role of government is to secure the rights of its citizens and administer justice, whereas the capital punishment is currently a legal method in the state of Utah of punishing a person found guilty of aggravated murder, whereas the Utah Commission on Criminal and Juvenile Justice found that over a 20-year period tracking death-eligible cases, state and local expenses totaled almost $40 million, for which only 2 new death sentences were realized, whereas Utah County is required to pay for the full cost of involving the prosecution and defense of such cases, which, due to their unpredictable nature and infrequency, create significant challenges for managing the county's budget and allocating over $1 million annually for related expenses, whereas Utah County is required to balance its budget each year, and the Board of County Commissioners of Utah County, Utah, desire to be fiscally conservative in their management of limited resources, whereas the death penalty is not a deterrent, as states where the death penalty is not an option have a lower average murder rate than states that still have it, whereas the last 2 individuals on death row in Utah to die did so due to natural causes, whereas many victims' family members are traumatized by the many appeals and prolonged due process afforded a convicted murderer as required by the U.S. Supreme Court before they are executed, whereas it is possible to achieve justice for and bring closure to victim families and members through a life without parole sentence, whereas such a sentence would reduce costs to taxpayers, deprive the murderers of celebrification through constant appearances in the press, bring swifter closure to victim family members, and keep convicts alive should they later be found innocent of their charges, whereas the death penalty carries risk of executing an innocent person, and since 1973, there have been 185 individuals wrongfully sentenced to death in the U.S. and later exonerated. Whereas in light of the risks involved with capital punishment, the U.S. Supreme Court has required a lengthy process of appeals and heightened legal scrutiny, which increases the costs to taxpayers and causes victim family members to wait a very long time for justice to be served. Whereas, in view of these concerns, the Utah County Attorney David Levitt recently announced that he would no longer seek the death penalty in aggravated murder cases. Now, therefore, be it resolved by the Board of County Commissioners of Utah County, Utah, that 1, we appreciate and support our hardworking law enforcement officials in investigating crime and collecting evidence that can ensure justice is served against those who commit aggravated murder. We recognize that there is a disagreement among victim family members as to whether the death penalty is a desired course of action in response to the heinous crimes they are compelled to deal with. 3, we sympathize strongly with victim family members and the extremely difficult position they have been placed in. 4, we desire that all offenders are brought to justice, especially in cases of aggravated murder. 5, we believe that given the risks and problems inherently involved in executing a person, justice can be served while avoiding these issues through a sentence of life without parole. 6, we support the decision of the Utah County Attorney to no longer consider capital punishment as an option. And 7, we call on the Utah legislature to remove this option from state law, as nearly 24 other states have done, and replace it with alternative measures that can still help ensure justice is served. So I brought this resolution forward for several reasons. You know, it came to my attention that Utah County has only ever successfully tried 2 murder cases to the point of death row. And of those 2 cases, one of them was executed, and one of them died of natural causes in the history of Utah County. And then we now face 2 more potential death penalty cases. And as we look at the cost of the death penalty, the average death penalty case costs us $4 million. We are required to not only fund the law enforcement and our hardworking men and women in law enforcement that bring in these cases, but we also fund the prosecution and we fund the defense. So as I look at any death penalty case, we try to do multi-year budgeting. We try to do the best we can with our budget. In the history of Utah County, if we've only ever had 4 cases and 2 of them are pending right now, how do we budget for that? And do these cases go away? No, they don't. What we find is 20 years later, we're still paying this because of appeals, because of the Supreme Court. While I'm not necessarily opposed to having somebody brought to justice through the process of an execution, what I'm keenly aware of is that due to the restraints on the death penalty that are placed on us by the Supreme Court, it causes appeal after appeal after appeal. And that creates a celebrity status for those on death row. That costs the taxpayers millions of dollars, that re-victimizes families over and over again. In theory, I'm not necessarily opposed to the death penalty. However, the fact that we've had almost 200 cases of people on death row exonerated in this country is very frightening to me. It is very frightening to me that any government gets to decide who lives and who dies. I see the need for compromise in many areas across politics, and I recognize that nobody is going to agree with someone else 100% of the time. I don't agree with my husband 100% of the time, and he's the first to tell you that. But what I can tell you is that there are 2 issues that I will not waver on. And one of those issues is parental rights, and the other one is I am pro-life, period. And that includes even an egregious crime, because I can guarantee you that the 180 so odd cases that were exonerated on death row was an egregious crime, and the people prosecuting it were sure that they had the right person. But apparently they didn't, and that frightens me. So I want to support this. As a county, it is difficult for us to prosecute it. We've only had 4 in history, and only 2 have actually gone to the death penalty. Only 1 has actually been executed. We don't have the expertise at the county level, and no county in the state of Utah does. And number 2, we can't budget for it. So this resolution doesn't prevent justice from being served. What this resolution does is it sends this to the state legislature to say the way that we handle egregious murder in our state is not working. The statistics show us that, and the cost is just too great to the taxpayers. So I support this resolution for those reasons.
Okay. All right. Any other comment or any public comment? Just want to know if there's any public comment.
And we do have
One on Zoom, okay. Let's take Representative. We'll take you first, since you're in the room, and then we'll go to we have 2 on Zoom. Okay.
Thank you very much for the invitation to speak and to be here with you. My name is Lowry Snow. I'm a state representative. I live and serve from Washington County, District 74. I am the chief sponsor of legislation that will be pending and I believe heard in the general session next year. That would essentially do what Commissioner Powers Gardner has so well laid out, not just in the resolution, but in her comments as well. And very well done. I couldn't have said it better. I am a conservative, and I'm honored to be before the commission of what I think is, without question, the most conservative county in our state. And in our state, it is the most conservative state in the union. So the thing that you are doing today, or anticipating doing, is not just a statement with respect to capital punishment and why you stand behind this, but it is a conservative position. And a lot of people don't understand that or appreciate that, but I would highlight what Commissioner Powers Gardner said about reverence for life, and the fact that there are some things that ought to be left to a higher power. And I am also pro-life, and I also strive to have that reverence for life, not just for a fetus in the womb, but life at every level. Now, the other thing, I want to add just a couple of things, and I don't want to take too much time, but in addition to what Commissioner Gardner spoke about, the costs, a lot of people don't understand because most of these people simply and are not able to pay for a lawyer, not just at the trial level. Much of the expense happens after the trial with many, many appeals, many, many review hearings. And you were right, Commissioner, that, and this doesn't take away anything from the local attorneys you have here and your own county attorney, but it's such a specialized area that the U.S. Supreme Court has made it that way. So many times we expend significant amounts of money, and we have some great attorneys in our Attorney General's office, but we have to find attorneys and pay attorneys who represent the defendant on death row. The other thing I would add to what the Commissioner has laid out so eloquently is that it's not about the money entirely, but the money and the fiscal issues ought to be a concern. $40 million expended since 2010 for no executions, 2 death sentences, but no executions. The 2 inmates who died on death row, waiting execution, died of natural causes. So I think our challenge is educating the public as to why this is important, why it's related to our conservative view, and why it's related to our fiscal view, and also a recognition that we can only do what we can do within the parameters that the U.S. Supreme Court has laid out. That isn't something that we did. That isn't something that our Utah Supreme Court laid out. It's due process layered on by the highest court in the land. And why have they done that? The cases are replete since about 1973. The U.S. Supreme Court talks about the finality of the death sentence. And because it is final, and because there's no way of correcting error after someone's life has been taken by the government, they have layered on, that's my term, additional due process to say, if you're going to take someone's life, you better go through all of these steps. Right or wrong, that's the system that we have to live with. I just have one other comment to make. Who I wanted to have with me here today was my constituent and friend, Sharon Weeks. I'd like someday for you to meet her, and she would have liked to have been here today. It's appropriate that this resolution is coming from this county because she is the sister of Brenda Lafferty, who was horrendously murdered, Brenda and her infant daughter, in 1984 in this county, was prosecuted and tried twice. Death sentence was imposed twice. The murder occurred in 1984. For 35 years, the state tried to execute the man. It didn't happen. In November of 2019, he died in prison of natural causes. The reason I wanted you to talk to Sharon is because until she talked to me and spent time with me, I didn't really fully appreciate what this did to the victim's family. She was promised, and her family was promised, that this man would be executed, that the death sentence would be imposed, and it would be executed. It never happened. Notwithstanding hundreds of thousands of dollars spent trying to accomplish that. That murder occurred in this county, and it was infamous, and it was a terrible event. It's interesting, there were 2 brothers involved. Ron Lafferty had the death sentence imposed. He died in November of 19. His brother Dan Lafferty, who was involved, his sentences were 2 life without parole sentences. He's still in prison, and he will die there. The family never hears about him and doesn't want to. We never hear about him, and we don't want to. He will die there. A death sentence has been imposed on him because it is a sentence of life without possibility of parole. So I applaud you for this conservative position, this conservative move, and I recognize that not all victims and not everyone feels the same way. But I started out by saying the challenge is educating people. When the people of our state understand why, when they understand the basis for it, most of the time they understand why it's important that we take this step. Thank you for your time. I'm willing to take any questions. I don't want to take any more time. I hope you'll forgive me if I went over. So
Thank you. Thank you. You said there was 2 online. So we'll let them speak for a couple of minutes each.
Okay, we first have Nan Ride. If you want to go ahead and unmute yourself and proceed.
I guess, is it me?
Yep, go
Can you
ahead.
hear me? Okay. My name is Nanette Ride. I'm the widow of Sergeant Corey Ride with the Utah County Sheriff's Office. And I just wanted to weigh in for a minute. I do agree with what the commissioner has already said about your stance for Utah County. But as a victim, I kind of want to weigh in a little bit, and I have some questions. And maybe this isn't the place, but I would really like a meeting with Representative Snow that just spoke. I've tried to reach out to him, and he does not. He doesn't answer my calls. So I feel like the big picture is not being seen here. My issue was our family has gone through appeal after appeal after appeal on the girl that was driving the vehicle the day that my husband was murdered. And I know personally the pain that our family has gone through and the Band-Aid ripoff that we have had to go through every single time an appeal happens. And I also know from experience that these criminals sit in a jail cell and all they do is think about something to do because they're going to go crazy. So they can obviously appeal till the cows come home. I feel like it is a broken judicial system. I think the system needs to be fixed, not just the death penalty taken off the table. I mean, why are these men that are sitting on death row right now, why are their sentences not being followed through with? Why are they sitting there for 30 years? That makes absolutely no sense to me. I can only be so grateful that the man that shot my husband on January 30th, 2014 was killed that day as well. And my family doesn't have to look at him or know that kind of evil is walking the earth, because I promise you, our safety is questioned every single day. I am now looking at the girl that drove the vehicle. She's going to be getting out of prison in 5 years on a technicality. She's still guilty, but the process is broken, and I would love our lawmakers to address that. And I'd like to be a part of that, too. I think it's really wrong that the parole board can let people off whenever they want to. The man that shot Corey, he served 5 years for stabbing his best friend 27 times with a screwdriver and running over him with a car twice in Utah County. And he was let off. 5 years, guys, 5 years. That's it. So there's too much power on the parole board. The system is broken. And I think it's so much more than just the death penalty issue that has to happen. I personally think if they get the death penalty, some people just aren't safe to be in society or ever see the light of day again. And I don't have a problem with them not being here as a victim. That's just my 2 cents. And I really do like what the commissioner said, by the way. I do support that.
All right, thank you. Thank you, Annette, and I'm sure that Representative Ride would love to have that conversation with you.
I definitely would. And
He's
if I can somehow get your phone number later, I'm more than willing to talk with you.
okay. Very good. We have one more,
Yes, we have Robert Anderson.
the sheriff.
If you'd
So
like
three-
to go
two more.
ahead and unmute.
Okay.
Hello, can you hear me?
Yes,
Yes.
go ahead.
I'm here because my family has been the victim of crime in Utah County. My little sister was brutally raped and assaulted, and I personally have seen Utah County attorneys leverage my family's suffering and pain to make their job easier and to get easy and cheap plea deals. And it comes as a shock to me that I read this in the paper, because when I think about people who are murdered in our cities, they don't have the opportunity to take a plea deal. When these killers kill them, they take everything from them, everything they're going to have. So I read over the resolution, and this resolution mentions cost and budget savings 8 times. It mentions the rights and concerns for the murderer 9 times. Guess how many times justice for the person murdered is mentioned? 0 times. The person who was killed, who had everything taken from them and their rights taken. And I would ask all of you, how much is justice for a person's life worth? Justice for a police officer, for a child who will never get to live their lives in our state, in our beautiful state. The county and county attorneys are lying to you to advance their personal agendas on this issue, seeing it as a conservative, principled issue. There's never been a single Republican president who has opposed the death penalty. The current conservative majority of judges on the Supreme Court all support the death penalty. The official 2020 Republican Party platform supports the death penalty. The Fifth Amendment of the Constitution is in support of the death penalty. The American people and your constituents support the death penalty. I won't get into the statistics because I don't have much time, but I'll just say that the most recent poll showed 71% of likely Utah voters, this is Salt Lake Tribune, 2017. The most recent poll showed 71% of likely Utah voters say the state should continue to impose the death penalty in capital murder cases.
Okay. All right.
And I would just
Thank
like
you.
to include, look at the time we live in. Fox News reported ambush attacks on police officers is up 91% in 2021. Murder is up 30% in the nation this year. From small towns to big cities, people feel defenseless. The killers are emboldened and they feel celebrated. Cop killers are cheered when entering their life sentences in prison.
Okay.
And at this time, I feel so horrible for the person who had to come in here, who I just had to hear talk about her experience of having a family member killed while on duty. And I fear every day I think of Officer Joseph Schiller, who was killed by someone hunting policemen. Matt Frank Hoover said he was out to kill police officers. This happened in Provo.
Right. Okay, we're going to have to. We need to move. We need to move on. We do have a hard stop, so thank you. If I can, Sheriff, just one. If we could, I would like to take a motion to adopt number 23, the resolution approving the tentative budget. I know that usually we have more discussion on that, but this is a handoff. And I know that you wanted to speak a little bit to it, but we have to pass this. We have to do this today. We don't have any options.
Yeah, so legally we need to adopt number 23, and then you want to come back to number 22?
And then come back, and then
we'll
come
speak,
back.
and then
We'll
hear
come right
from
back.
the sheriff?
Yeah.
Okay, give us 1 second.
I will have probably a contrary motion.
On the number 23, adopting the tentative budget.
I'm sorry. My brain was on 22. I
Sorry,
apologize.
I skipped back and
Yeah,
forth.
no,
So
I want to get caught up.
Okay.
So we're talking 22 or 23.
23. And then we can have a lot of further discussions. This is just tentatively adopting the budget. I'm sure there'll be a lot of discussions. I have some, started some. We'll have more in that in the future.
I have not read the entire tentative budget, but based on what I currently know, I'm willing to go ahead and adopt a resolution to approve the tentative budget.
Okay.
And
that's
I
your
will
motion.
second that.
Okay, I get a motion and a second to adopt the resolution approving of the tentatively adopting the tentative budget. All in favor, say aye.
Aye.
Aye. That passes 3-0. Thank you for allowing that, Commissioners. Sheriff.
Thank you, Commission. I'm Mike Smith, Utah County Sheriff. I just wanted to take a minute and first off say that I appreciate everybody's point of view on this. It is such a complex issue and a difficult issue to wade through. And I truly do appreciate everybody's viewpoint and the callers that called in. Thank you for your thoughts as well. I just wanted to bring up a few things. I'm troubled when we look at justice from a budget. That troubles me. I think as we look at these issues, and we've had some heinous issues in Utah County, and I would like to say that we will never have them again, but I can't say that, and no one in this room, I would hope, is crazy enough to say that because we don't know. And to close the door on something that to me is when we talk about the death penalty, the way that the law reads, for one, when you talk about the budget, the law does not compel any county attorney to apply the death penalty. There's nothing in there saying the county attorney has to use the death penalty. So if each county, each case, they can weigh it out. We've had some egregious cases in this nation, in this area. And the death penalty, in my opinion, is very applicable to those circumstances. So why would we close the door on something that is used in case management, in the strategy of county attorneys? And again, it goes down to the county attorney and his team to make that decision. Allow them to make those decisions. And when it comes to our representatives in this bill and our state legislature, it's their job to make that decision. If this bill goes before the state legislature and they decide that they want to get rid of the death penalty, well, we all elected them into these positions. And whether I agree with it or not, I don't, but whether I do or not, that is their job. And my plea to you would be, allow them to do their job. But in the meantime, the state law says that there is a death penalty in the state of Utah, and that we honored that law because we took an oath to uphold the Constitution. So I would ask that we do that and plea with you that I am, more than anything, very troubled when we look at victims in this case. And I've heard some very egregious things said about some of the cases we have and standpoints as it comes to just a budgetary issue. And it's sickening to hear that. It's sickening. You talk about re-victimizing somebody. We'll talk about victims with a dollar sign attached. That's re-victimizing somebody. So allow our county attorneys to sit down with the family, to look at the case, to look at all of the factors and weigh out what's best for this case. And I don't think it's right for Utah County to just close the door on a law that's on the books. Thank you.
Okay, thank you. One more. David?
Commissioners, you know who I am, but for the record, I'm David Levitt. I'm the Utah County Attorney. I want to start by thanking Nanette Ride for her comments. She is a victim with whom I have worked personally and whose life has been turned upside down because of the re-victimization that occurs inside of the criminal justice system. And there are hard decisions that need to be made in cases that are caused by things that are outside of our control, which was one of those decisions was in Nanette Ride's case with her husband, her late husband. And I'm grateful for her willingness to come and speak today. I would also, and I'll make sure that Representative Lowry has Nanette's phone number, because my experience with Representative Lowry is that he'll absolutely be happy to visit with Ms. Ride. I'd also like to speak in agreement to what our sheriff, Mike Smith, has said. I have a difficult time philosophically putting a dollar amount specifically to crime. Our job as law enforcers is to seek justice and to bring perpetrators to justice. And so I agree wholeheartedly that this is not and should not simply be a dollar discussion. But the realities of what we do requires that we engage in resource management so that we can cover the needs of all victims. Let me simply say this on this topic. I have 18 homicide or attempted homicide cases in my office. Each one of those homicide cases is presided over with two lawyers, each of whom have more than 100 cases each in their caseloads. I have 231 sex cases. Every one of those sex cases has a victim or victims whose cases are presided over by deputy county attorneys whose caseload exceed 100. When I elected to seek the death penalty in a case recently, or 2 years ago, I won't get into the particulars of that case because there's a gag order imposed and I won't discuss the particulars of it or even name the name. But when I got involved with that case, we realized that that case has required 4 full-time lawyers, a full-time investigator, a full-time paralegal, 4 full-time public defenders, and that's for one case. Now, the victims in my 17 other homicides, tragically, are just as deceased as the victim in the death penalty case. Their loss, the loss of the families, is no less. And so, as I have weighed this option, both in seeking the death penalty originally and then electing to no longer seek the death penalty, I did so with victims in mind. Because you can't put a price on a victim's peace. And I detract from the peace of my other victims, hundreds of them, by seeking a sentence that I concluded will never be carried out and is the ultimate bridge to nowhere, criminal justice, speaking in terms of criminal justice. And so if it will never be carried out and it detracts from victims, then why would we seek it? And my conclusion is, for the betterment of our community and the protection of our community, I would not. Now, I am in a very small group of Utah County attorneys. If you look at county attorneys in the modern era, in our lifetime, Noel Wooten served as county attorney from the early 1970s until the mid 1980s. He charged the death penalty. He charged Gary Gilmore, and he charged Ron and Dan Lafferty. After that, Steve Kilpack, the next county attorney, didn't charge the death penalty. Kay Bryson, the next county attorney after that, didn't charge the death penalty. Jeff Buman, the next county attorney after that, never charged the death penalty. I am the only county attorney in 35 years to actually charge the death penalty. And so I find somewhat humorous the assertion that I'm somehow not tough on crime. It just so happens that my responsibility is to the residents of this county, and that requires leadership. And I applaud you as a county commission if you adopt this resolution, because the death penalty hurts victims as a whole. The death penalty is not a deterrent against crime, because crime, for punishment to be a deterrent, it has to be carried out in some swift proximity to when the crime is committed, and 35 years just doesn't do it. And so I will end by saying this. The most critical thing to our protection as a community is the upholding of the standards of our Constitution. The death penalty as currently used by prosecutors across the state is as a leverage point to persuade people to plead guilty so that they can avoid the death penalty. What that really means is that the government of the state of Utah is saying, we won't kill you if you'll agree to not make us prove our case and serve the rest of your life in prison. That violates the constitutional oath of every police officer, of every county commissioner, of every prosecutor, because we should be vigorously welcoming the opportunity to prove our case. And we will prove our case, but we will do it with life without parole, which protects us. And I would urge you to pass this resolution.
Thank you.
Okay. All right, we'll bring it up here. Any further discussion?
I just wanted to point out, the horrific Lafferty case, which was the last one to actually be tried for the death penalty in this county, I was 2 years old when that murder occurred, and I was 37 when Ron Lafferty died of natural causes. I'm 39 today. That means that for literally 1/20th of my life, he was not on death row, which means that for 19/20th of my life, he was, and he was never executed. I was 2 years old when that occurred. I was 37 when he died of natural causes.
Any other thoughts before we entertain a motion?
Yes. We've had repeated on different topics, other topics, the idea that the Constitution is antiquated and needs to be replaced for a variety of settings. The Fifth Amendment, of course, as we already heard, does allow for the removal of life for cause. The cause of life removal, to take away from someone else their life, is based on the enormity of the crime. Crime should match, the punishment should match the crime. We all know the story about stealing a loaf of bread to spend a life in prison in antiquity stories. And in some cases, that's still going on. Those are ridiculous, of course. But the county attorney's statement a few weeks ago, and I supported that and still do, is a wake-up call for the legislative body to help us fix this mess. We perpetuate agony for decades for one person. We spend millions of dollars because of a process. We don't ever see justice out of it. Hence, a punishment should always match the level of the crime committed and not have an exaggeration or based on prejudice or vindictiveness. It should match the enormity of the crime. Should there be perhaps a resolution that we encourage the legislature to fix the mess that we're facing? I was reading recently the Republican National Committee's where it says they condemn the Supreme Court's erosion of the right of the people to enact capital punishment in their states. In solidarity with those who protect us, sheriff, police, law enforcement, attorneys, county attorneys, attorney generals, we call for mandatory prison time for all assaults involving serious injury to law enforcement officers, and what it does not say here, for regular people. I understand the direction where this resolution is going, but I think we're at a crossroads where we got the attention, and the resolution should not end the death penalty. It should fix the process to achieve a right, principle-based death penalty sentence, not end it. So I worry that the resolution will send a mixed signal that we're completely opposed to all death penalties, thus taking away from the county attorney the option to prosecute for death penalty or not to prosecute for death penalty. And if we avoid the resolution, we allow him that latitude to continue to decide which way he wants to go with that, while working with our state representatives, who are actually the sole authority on writing the law of this thing, and working with at the national level to fix the issues that we face with the Supreme Court. The underlying issues why we have decades-long back and forth, lifelong appeals for every crime or every murder. There are horrendous stories of murder that are obviously who we know who did it. And there are others that we don't. And you mentioned 149, I think?
185 or 83.
But there's many, many that we're able to confirm through DNA testing that person was never even there. And that has to be addressed. But what I don't want to do is take away from the attorneys at any level the ability to pursue the death penalty.
In clarification, the resolution actually would not tie the hands of the county attorney. As an independently elected official, he would still have the ability to do anything in contrary to the resolution. So the resolution does not tie the hands of the county attorney and would not prevent him.
I understand that. I'm anxious that the resolution may send a mixed message to the legislative body and the general public. We already have a public statement from the county attorney. I gave voice to that statement and support of that statement, but I think the resolution is a step that's not necessary and may cause confusion in the public. And that's where I think hearing from the attorney now, hearing from the sheriff, the state representative, others who have been on here, Ms. Ride, I'm very familiar with that case. I remember that well. I'm just concerned that this resolution will cause a bottleneck, and that I don't want to do. I want to have the legislature maybe even tasked to seek a resolution to this, to get this resolved and fix the process so we can have a clearly identifiable capital case that is worthy of a execution and done with an expeditionary time, not over decades of time.
Okay. All right.
You mentioned that we were pro-life. I am definitely pro-life. And that's all the more reason why I say that the punishment should always match the crime. And for the, as you know, I had that resolution written up to counter property tax exception for Planned Parenthood of Salt Lake because they have an office here in Orem for that very basic reason. Innocent people being killed for no particular good reason.
Right. Okay. I have a lot to say, but I'm not going to say it all. I'll just say that this is an issue that this is not an issue that I just come across this year. It's been one that I've looked at, worked through for a long time. There's a lot of, and I acknowledge that there's a lot of moving parts to it. There's a lot of emotional issues attached to it, and you know, we have. It's not that the capital punishment one is the only death penalty. I mean, life without parole is a death penalty. I mean, it's a sentence to death, is what it is. And I always find it interesting when we give multiple life sentences without parole. I don't know what that means, but and so for me, this is a resolution that states that, just as I see it, is it says we need the state legislatures to act. We want them to come forward. We want that discussion to happen, and you know, by us passing it, all it is sending a signal, right or wrong. It sends a signal. This is an issue. We don't want to put a price tag on things, but we do live in a world in which we have to weigh the differences of how much resources we put here and there. We don't have endless supply. And so we have to weigh those differences back and forth. And we are the individuals that have to look after the purse strings of the public. And so is there a motion?
Yeah, I will make a motion to pass item number 22 and the resolution declaring support for repealing and replacing the death penalty.
And I cannot support that motion.
Okay, I will suspend the rules so I can second, and I will second that motion. Any further discussion?
I want it to be known that I feel that our state legislature has done all they can to fix the process of the death penalty in the state of Utah. But the problem is, at this point, it's out of their hands and it's in the hands of the federal government. And as it stands with the federal government, I believe that we should repeal the death penalty in the state of Utah. If in the future the federal government were to refine the process and make it so that it was a more just process for the victims, then I feel that we could reverse that. But as things stand with the federal government, our state legislature has done all they can at this time, and the only other thing that we can do is to repeal and replace the death penalty.
Any other further discussion? Okay, all in favor say aye.
Aye.
Aye. And opposed?
Nay.
So that's Commissioner Gardner and Commissioner Lee in the affirmative and Commissioner Sakovich in the negative. All right. With that, then, is there any general public comment? Seeing none, final.
We do have one.
Oh, we do?
We
Okay.
have one general comment.
That's right.
Morning, Commissioners, or afternoon. My name's Eldon A. Neves. It's been a long time since I've been here. I was surprised you let me back in. It's really great to be here doing all this discussion. I was going to say that I had missed how exciting these meetings were, but as a matter of fact, they were it was good to be here for this latest discussion particularly, as well as other, and I've missed it here. Commissioner Lee, you and I are good friends, and it's been a couple of years, and I intend to be coming back. I wanted to, about 2018, we had the fires that you're aware of. Everything was burned up. I had 65 cattle burned, and recently we had the whole bottom of Lake Fork, Dairy Fork, blown out in the rains and so forth. 40-some foot high wall of water went out and tore everything out. It's hard to believe what happened in there. However, the reason I'm here today is to I want to thank Richard Nielsen and also Glenn Tanner. They probably have gone already. But to thank them for the way they responded and helped us with the road work that needed to be done there. We weren't able to get out, and or to get in and take our cattle out and so forth. We're still in the process of taking them out. Right now, there's a mud hole that, as a matter of fact, I had to shoot a bunch of cattle and put them in there as ballast, so we could run over them. I'm just joking on that.
A little.
I was, yeah.
I was just joking.
Okay.
But don't send anybody. But anyway, it's a mud hole, and I talked to Glenn a couple of days ago, and he said he would go take care of that. I hope he is, because we're right now unable to get in there because it's such a miserable piece with the rains and so forth. But if you get a chance, you ought to ride into. I've got a key into there. The Forest Service closed that off so they could keep the public out. One gentleman rode out the 40. He rode it out in a hammock with the water underneath him. The public sometimes are not, the civilians are not the brightest in the world. Us cattlemen are, but they are not. So anyway, thank you very much for having such a good, Glenn and Richard. They're remarkable people. And if they don't take care of that mud hole, I'll come and see you. But I'll also resolve, Commissioner Lee, that I'm going to come here I was here, as a matter of fact, for the last 2 months. I've been here at 9 o'clock every day, or every Tuesday, and nobody was here. I thought
things change.
But they do change, and I should have been notified. But anyway.
Yeah.
Anyway, I'll be here.
Okay.
Well,
but
thank you so much
very
for coming. It's a pleasure to meet you.
Okay.
Thanks for listening to me.
Absolutely. Thank you. And we'll let Glenn and Richard know. Thank you.
Right. Final motion.
I'll make a motion.
Could I just make one comment before we close?
Yes.
Just for clarification, with regard to item 23, the tentative budget, just for clarification for the minutes, that they reflect also that the budget officer has submitted a budget message, and that is a part of the materials that were submitted as a part of that budget adoption.
Thank you
Note
for that
into it,
clarification.
Okay.
I'll make a motion to adjourn then.
I'll second that motion.
We're now adjourned. Thank you.